There have been many legal problems for Ripple in the past, and this lawsuit is just the most current one. You may have heard that some of them have been ruled by the courts to be stocks. XRP is an example of a case where the court ruled that the token used by Ripple, XRP, is not a security in and of itself. There must have been a reason why the SEC was so interested in Ripple. What makes cryptography unique, and why does it need to be changed? What the Securities and Exchange Commission (SEC) has really done is just hire more lawyers to carry out regulation through enforcement. Since we have made so much progress since the beginning, it would be good to look over your case with the SEC. Talk about how you would describe how the fight has grown since it started. This coming Tuesday, February 20th, they have failed many times before, and the Ripple case was no different, no matter how worried these people were. Additionally, Gensler has already said that a lot of these are considered stocks. The audio clip you just listened to says that Ripple's cryptocurrency, XRP, is not seen as a guarantee. In all of these cases, this choice is the right one. The Securities and Exchange Commission (SEC) chose to focus their first big move on Ripple for a specific reason, as far as I know. There was a time before the lawsuit when we had already asked for more rules. This is a great step towards making the rules and laws that should govern cryptocurrency public now that more countries have joined. The unique features of cryptocurrency should be taken into account by these laws and rules. Since being honest, the Securities and Exchange Commission (SEC) has started suing a lot of people and has hired more people for lawsuits, which it calls regulation enforcement. Our case against the SEC was successful on all important points. However, it is unclear whether this will be taken to court or not. What will happen? I guess we'll find out. In order to do what they wanted, they asked for permission to file an appeal at every stage of the process. The courts also turned down the case, which meant that Chris Larson's claims were no longer valid. The Grayscale case made me think that the Securities and Exchange Commission has never done a good job with its past. Almost certainly anyone who has been watching the Coinbase case has seen that the court does not agree with the SEC's reasoning. The case will probably be over either when the Securities and Exchange Commission (SEC) finally admits that they are losing or when Congress makes new rules. The CEO of Ripple, Brad Garlinghouse, recently told Bloomberg that the U.S. Securities and Exchange Commission (SEC) has lost the ongoing case. This could have a big effect on the price of XRP. Besides talking about the current issue, he also talked about new developments in the justice system and how they relate to the problem at hand. During the interview, Garlinghouse said that he was right about what he thought. He also said that the SEC's case against Ripple failed for all of their main reasons. He talked about how the court said that XRP is not a security asset. The chief executive officer of Ripple also said that the action's outcome would depend on whether the government body decided to keep trying what he sees as a completely pointless thing to do. In the eyes of the CEO of Ripple, the SEC doesn't matter anymore. The Securities and Exchange Commission (SEC) and Ripple are still in a long-running and heated court battle. Since both sides are unwilling to give in, the market for digital goods is currently holding its breath until a solution is found. At the start of 2024, a lot of people thought that the case would be resolved in a way that would make it possible to set a very high bar. According to Brad Garlinghouse, CEO of Ripple, who was quoted by Bloomberg, the SEC has already lost the case. This could be a big step forward for other cryptocurrencies. To be more specific, he said that the group had failed on every front that mattered to them, which means that Ripple had won every court case that was important since then. Second, speaking of all the big worries the SEC lost to us, said Ripple's CEO. The Securities and Exchange Commission (SEC) is getting ready to go to a higher court with an appeal of the ruling. Things that happen will be shown to us tomorrow. During the hearing, he also said that the courts had earlier thrown out the government's appeal. On top of that, he thought Brad and Chris Larson were treated poorly when their claims were settled. Last but not least, Brad said that the Securities and Exchange Commission (SEC) would give up its power if either of two things happened. He then said that the group would have to admit loss no matter what, or Congress might step in and help them. He told Bloomberg in a recent interview that he wasn't sure about the second thing, even though he was hopeful about the first possible outcome. The CEO of Ripple, Mr. Brad Garlinghouse, put out a statement in answer to what the SEC did. There is an explanation by Garlinghouse that shows why Ripple needed court orders to get more information about the rules and the possibility of an exchange-traded fund for XRP. Though the price of XRP fell by 1% on Wednesday, the SEC kept it at 55 cents on Wednesday. A statement from Brad Garlinghouse, CEO of Ripple, in response to the case and rumors of an exchange-traded fund that uses XRP has been made public. As the payment transfer company tries to get into the Bitcoin custody market, they have recently become a regular custody provider. During business on Wednesday, the price of XRP stayed above 55 cents. Chief Executive Officer of Ripple says that the company has won its case against the Securities and Exchange Commission (SEC). Brad Garlinghouse, the CEO of Ripple, said that the company is going to court because it is having a lot of problems. Judge Annalisa Torres' order on July 13th to treat XRP's secondary market activities as if they were not securities is most likely what Garlinghouse is talking about when he says this. In his speech, Garlinghouse said that the Securities and Exchange Commission has lost all of its cases against Ripple and Coinbase. This was brought up when he was talking to Bloomberg. Ripple's lawsuit ended on Wednesday, which meant that the discovery part, which was all about possible solutions, was over. The well-known author Charles Gasparino says that Ripple's legal action against the U.S. Securities and Exchange Commission has not led to any good outcomes. Garlinghouse thinks that the Securities and Exchange Commission (SEC) will quickly accept that it has not been able to go after businesses that deal in Bitcoin. In contrast to what most people think, the vast majority of people think that this statement is not true. Even though it was just decided that XRP is not a security, Gasparino thinks the decision is ridiculous because it makes Ripple's win in court look weak. However, it is still true that Judge Torres' incredibly stupid move to split the baby with the Southern District had a short-term effect on retail XRP investors. He used the word victorious to describe how he felt when he saw the court's decision. According to the Securities and Exchange Commission (SEC), cryptocurrency is not a security. This was proven by the Ripple case. Brad Garlinghouse and Chris Larson, two leaders from Ripple, were charged with breaking securities laws, but the charges were dropped before they went to court. The Securities and Exchange Commission had already tried to appeal the decision but failed. Like Adam Box did with BlackRock's Ethereum exchange-traded fund, Gasparino did the same thing with the decision. He said it was unfair and made sure that the legal community would agree with him. An enormous fire broke out because people in the XRP community didn't agree with the journalist's analysis. Bill Morgan, a lawyer who specializes in cryptography, said that the outcome was usually praised by other lawyers during the course of his case. He set XRP apart from other types of assets by stressing how reliable it is as a coin. Crypto law's defense against the decision was that most XRP transactions don't meet the requirements to be called securities. A lot of people in the XRP community have used insulting language against Gasparino, even though Ripple is still in court with the SEC, while Ripple, on the other hand, keeps leading the way.